Welcome. This is the Employment Law Channel on the Legal Broadcast Network. Fortune published an explosive interview with Carol Bartz, who last week was fired as Yahoo CEO after 32 months on the job. In it, she referred to her fellow board members as, among other things, doofuses. She did have a disparagement clause in her contract, which still has $10 million left. My guest is Kathleen Peratis. She is partner at Outten Golden. Kathleen, welcome back.
Thank you.
Kathleen, talk about the disparagement clauses in contracts like this. How much teeth do they typically have?
Well, they have as much teeth as the parties decide they're going to have. Often the anti-disparagement clause is very hotly negotiated, but it's generally hotly negotiated when the employee or the former employee has in mind to write a book, or to do a television program, or to in some way use her work experience as part of what she's going to be going on to do in the next chapters of her life. Saying, using disparaging words about your former colleagues is generally not something anybody thinks there's much of a question about. You don't call your former colleagues names. So the fact that she did it is a little bit unusual, probably covered by a disparagement clause. The question is going to be how likely is it that the company, that Yahoo's going to come after her, and how likely is it that she's going to resist any of their suggestions as to how she ought to behave in the future.
With the understanding that somebody at her level suddenly is fired, she is approached by the media and in the heat of the moment says something. Is that understood by both parties? Do typically companies understand that in any way, or is it pretty much cut and dry, do you think?
No, I don't think that there would be any understanding of that. At this level, I think that you're expected to behave in what is called a professional manner at all times. Her calling her former colleagues names like that is pretty unusual. I think that there could be an issue, just hypothetically, if it were to go this far, to some kind of decision maker, as to whether forfeiting $10 million is actually commensurate with the harm. Calling your former colleagues doofuses is probably not worth $10 million. But my guess is that they will, their lawyers will have a conversation. She will promise not to do it again. There may be some other kind of arrangement or deal made, but I would be surprised if we hear too much about it in the future. I don't think it does Yahoo any good to pursue it if they can avoid pursuing it, because after all, the press stories just compound the injury. They don't want to have a whole string of occasions for the press to remind everybody that she called her former colleagues doofuses.
I guess if Yahoo decides to take the low road and not pay her, what recourse does she have?
Well, she's got a contract to enforce. She's got, presumably, either in her original employment contract or in whatever agreement they made when she left the company, they have agreed to pay her a certain amount of money. And if they don't pay it, she sues them for breach of contract. They then would respond to that by saying she breached the contract, and this is their damage for her breach of the non-disparagement provision. And then some fact finder or judge or jury will decide what that breach is worth. I doubt it's worth the whole $10 million.
All right, she is Kathleen Peratis. She is partner at Outten Golden. Kathleen, always a pleasure. Thanks for joining us today.
Thank you.
This is the Employment Law Channel, an affiliate of the Legal Broadcast Network.